The immediate past Minister of Interior, Rauf Aribeshola, has reacted to the abolishment of some of his legacies by the Osun State House of Assembly, saying that the ruling People's Democratic Party will know the consequences of its action when seeking re-election in the next governorship election in the state. The Assembly had repealed the Osun State Anthem, Crest, and Flag Law of 2012, which was introduced during the administration of Aribeshola. The Speaker of the Assembly, Adewale Egbedu, during plenary recently said the action was taken in compliance with the judgment of the Federal High Court of December 14, 2017, which was against the renaming of Osun State to State of Osun. Reacting to the reversal of the law, Aribeshola's media aide, Shola Fashire, during a radio program in Osogbo on Thursday, said the administration of Governor Ademola Adeleke and the PDP were already defining their chances in the forthcoming gubernatorial poll. He said the overturning of Aribeshola's policies had begun since the government of former Governor Boyega Oyetola of the All Progressives Congress, and that the PDP only completed it. Fashire said he was not surprised that what Oyetola started was completed under an opposition party in Osun State. Fashire said the Oyetola-led administration only reversed the reclassification and single uniform introduced by Aribeshola. He said the changes were made by Aribeshola's administration in conformity with the regional plans of the Southwest, that the people would decide the fate of any government that plays politics with their identity. On alleged collaboration of Aribeshola with Governor Adeleke in the July 16, 2022 governorship election, Fashire faulted the Ileri Oluwa-led faction of Osun APC for peddling such information, saying they are battling with witchcraft. He said Aribeshola never at any time worked for the election of Adeleke, and the reversal of the state's name was not to spite the former minister. Fashire, however, insisted Aribeshola has no political relationship or cooperation with the PDP. It is not impossible that individuals within his supporters would have collaborated with the PDP in one way or the other, but neither the top nor Aribeshola had any relationship absolutely with the PDP. A federal high court in Abuja has dismissed a fundamental rights enforcement suit filed by Nnamdi Kanu, leader of the indigenous people of Biafra, IPOB, against the Department of State Services, DSS. Justice James Omotosho, in a judgment on Thursday, held that Kanu's suit lacked merit and ought to be dismissed. In the suit marked FHC/ABJ/CS/482/2022 and filed by his lawyer, Kanu has sued the Director General of DSS and the Attorney General of the Federation, listing them as first to third respondents, respectively. In the suit, the IPOB leader alleged that the DSS subjected him to different inhuman treatment, including denying him his right to wear any clothes of his choice, like the Igbo traditional attire called Ishago, while in their facility or any time he appeared in court for his trial. He alleged that the security outfit, while allowing other inmates in their custody the freedom to choose and wear any clothes of their choice, was restricted to wearing only a single clothing. The applicant also accused the DSS of subjecting him to torture, breaching his right to dignity, among others. He therefore sought an order directing the respondent to allow him to put on any clothing of his choice while in the facility or when appearing in public, among other reliefs. But in a counter affidavit filed by the DSS and its DG, they urged the court to dismiss Kanu's case. They said that the operatives had not and had never tortured Kanu either physically or mentally while in their custody. According to the DSS, the applicant is kept in their facility where every other suspect is kept. They said it was untrue that other suspects were allowed to put on any clothing of their choice, including Hausa and Yoruba traditional attires. They said the facility was not a recreational center or traditional festival where Kanu and other suspects would be allowed to adorn themselves in their respective traditional attires. They argued that there is a standard operation procedure on a dress code by persons in their facilities. They accused Kanu's family of bringing traditional attires and other clothing with Biafra signals and pair of red shoes decorated with shining beads for him to wear in custody and also to attend court for his trial. According to the DSS, the clothes have colors of the non-existing Biafra Republic, which is the subject matter of the applicant's criminal trial. They said the Ishago attire, popularly called chieftaincy attire, was not a suitable dress for persons in detention facilities and was against its SOP. They also argued that Justice Binta Nyako, where Kanu is currently standing trial, had directed that Kanu should be allowed to wear any plain clothing of his choice and that anything contrary will contravene the court's directive. The DSS said they never breached his right to human dignity as alleged by the IPOB leader. Delivering the judgment, Justice Omotosho held that the right to human dignity is contained in Section 34 of the 1999 Constitution. He said it was clear that a right to human dignity related to rights against torture and inhuman treatment, among others. The judge held that Kanu's case did not relate to torture or forced labor, as he was never tortured while in custody based on the evidence before the court. He said a right to dignity was not a right to change clothes as an inmate in a prison. Besides, Justice Omotosho held that Kanu failed to provide the photographs and names of inmates who were allowed to wear different attires while in custody. He said the onus was on him to prove his case, but the applicants merely rely on bare facts without any evidence. He described the IPOB's leader's allegation as a hypothesis without concrete evidence. However, the judge consequently dismissed the case for lacking merit.